For the appellant.
2 minutes. A court without subject matter jurisdiction is like an orchestra without a pit or a plumber without a wrench. This case is about a predatory lender based in New York that strip mines the public in Tennessee with loans disguised as business cash advances or as advanced purchases of future receivables. And it does so outside of the regulation of the state of Tennessee because it is not banking and these are not loans. So this is an industry which is not subject to the rules for loans. It's a very large industry. I'm in business, and many people I've talked to have used these types of funders, business funders. So the American genius for capitalism and profit in this case collides with the moral speed trap of the usury law. The usury laws are intended to protect the ignorant, the weak, and the poor from rapacious and advantageous smart lenders such as Flexibility Capital. And the court, so the case has two main parts. One is the nature of the contract, and also the second part is about the court. The courts lose their virtue, they lose their moral purpose, and they lose their role in justice when joining and aiding with the wolf in this case. Despite proper pleas by the appellant that the court cannot hear a void case, I would say it's voidable, but I would go further to say it's a void case. This case empowers this court and the courts in Tennessee to deal for the first time with this issue of business loans of this kind. These are loans, and this case empowers you to give a clear ruling on this type of contract operating across the business spectrum, medium and small size business across our state, with a huge book of business as Flexibility's debt collector can attest. And so I'm asking for a clear ruling on this. There are many cases out of New York where these people work. There's a good federal case on this, the Shoot the Moon case, which I cite in our petition. Is this a lawful contract? Is the question. If it is a lawful contract, then the court has subject matter jurisdiction in Hamilton County. I contend, having analyzed the contract, that it's not, that it is a fraudulent contract. If you look at the name on the front page of the contract, which is 14 pages, it's in the record, it's called Future Receivables Sale and Purchase Agreement. Well, that's fine for 10 pages of type suggesting, as it did to the defendants in the trial court, suggesting that this is an advanced purchase of future receivables. In fact, we did argue and we defended the contract in those terms. But if you look further, pages 11 through 13, it is not that. It is a personal guarantee of the owners of the radio station. I'm in the radio business. I do a report every morning for 3 hours with politics, law, religion, and so on. That's my calling as member of the press. Who is actually the client that you have that you're representing on this case? I'm David Toulis. I'm the appellant. Okay. You're representing yourself? Yes, sir. Okay. Go ahead. The guarantee overwrites the contract in the first part. So the guarantee makes this a loan. It is not an advanced purchase of future receivables. And in fact, we were so confused in this litigation. We as I said, we defended that this case accepts, the lender accepts that our business has gone down in the COVID-19 state of emergency. We were effectively put out of business. The contract indicates that these people will wait for us to get back on our feet. And so, in fact, in the hearing in the court, We argued for a Rule 8 sanctions against Mary Cheadle for calling it a loan, because it's not a loan. We said this is not a loan, and we said she needs to be sanctioned, and the judge denied that. The case Jenkins versus Duggar gives the 4 essential elements of usury. There's a loan for forbearance. There's an absolute requirement to repay. That's an essential element. And third is it violates a statutory limit. And there's also mens rea intent. Now, the statutory limit is at 47-14-103, and the limit on loan requirements of a debtor is 10%. This case, you could say, is void because there's also, and the litigation is void because there's no meeting of the minds on the agreement. Here we are, two sides, each arguing opposite of each other, and in the course of the case in circuit, we effectively changed positions, still on the opposite side. So where is the meeting of the minds? How can there be an enforceable contract if the parties simply don't understand what it's all about? Is it a sale of future receivables that you're looking at in the papers, or is it a loan? The loan hallmarks are in my filings, but these are not points made by Flexibility. Flexibility doesn't really attempt to defend its contract, but let me just say quickly, just FYI, because I know you want to give a clear writing about this type of business. Loan recourse powers against the lender against the debtor is all the instruments, the equipment of the radio station. There's a UCC-1 loan for all of its assets. On page 8 in paragraph 26, the contract says effectively that Flexibility can run the radio station. So the asset claim range is very broad. Again, that implies, if you read the Cap Call versus Shoot the Moon case out of Montana, which is a very detailed discussion about this whole type of business, that implies, again, a loan in operation, not a true and genuine purchase of advanced receivables. But also, now the contract has reconciliation provisions, which are important to that federal judge. Also, adjustment features where the rate of payment can go up or down. Well, those look good, but we paid $164 a day every weekday taken out of our account. And then when the economy crashed at the hand of the governor, the last payments were for more money than we had. So again, that's not, if you're buying receivables, you're buying a $100 check from a small business, a $500 check from a bigger business, and you get that portion. Well, here we have payments that are drawn out from the account regularly as loan payments. These are the treatment is of a loan. And Flexibility has been silent about these details, and I would say has waived them, but I would ask you to look at them because I'm hoping for a clear analysis in Tennessee on this type of transaction. And so points waived. There are, at the very first page of the complaint, Your Honor, an admission against interest, meaning it's a highly credible admission, and it's 2 quotes: the plaintiff loaned defendant's money, defendant failed to pay the money back. Okay, here we have the people who are extending the blessings of this credit, calling it a loan. The second quote on also page 1, this is a straightforward collection case to recover the balance due on a loan. Well, I mean, maybe all these words are needless, but that is an admission by Flexibility of what its business is all about. And the rate of interest, just guess, 208.05%. That's, if it's a loan, that's how much the interest rate is. If it's not a loan, of course, you don't calculate the repayment in terms of percentage, because if the business ebbs and flows, the repayment varies, and it might take there's an unclear terminus as to when the obligation is finally met. But it is, if it is a loan, that's the rate of interest. Does the court in circuit Hamilton County have subject matter jurisdiction? The answer is no, and that's because this is unenforceable. It's an unenforceable claim that violates our law, and also it violates New York law with a 25% limit on loans, and it's a felony to do it in New York. I haven't seen any felony cases filed, but here it's a misdemeanor to knowingly do this. It's a felony there, and in the litigation, we put Flexibility on notice. We put the law firm on notice, hey, this is a criminal activity. these are you're reaching into Rule 8 again. Watch out. The circuit court says, yes, it has subject matter jurisdiction, despite pleas that are not untimely. When you challenge subject matter jurisdiction, it's not untimely. And is it timely? Well, the judge said this is an untimely challenge. I've ruled what I've written. I have written, and just appeal it. He failed in the job of deciding when it's properly raised. And there we were at that hearing. A document in the record was submitted in detail, and that same day, and I turned to the flexibility representative, please defend subject matter jurisdiction. Flexibility did not, and the judge did not say, well, ma'am, you have the floor. Now, how is it I have jurisdiction given these claims orally made about the nature of the contract? Circuit has authority to enforce contracts in TCA 1611-115. Of course, these have to be lawful. They have to be honorable. And the circuit court says it can enforce, and it has enforced against me a 208%, 0.5 interest rate. It says also that I'm not bound by TCA 47-14-103 and the 10% limit. I'm not bound by that. Flexibility does not have to defend subject matter jurisdiction. When challenged, there is no subject matter jurisdiction that's untimely. That's Red Wing versus Catholic Bishop case is the leading case on that point. Standing, flexibility has no standing. You can't come in with dirty hands. You can't come in with red ink on the equity side. It's coming into this case with negative equity and has no harm for which relief can be granted. It has no harm. It can't show any harm. So that's why I suggest that this is a void case. You may say, well, it's void. It's not. We won't go that far. It's not void. It's just voidable. But Circuit had a duty to decide it when it was raised. It had a duty for yet another hearing. That was my right to have that done there and not to have to come here. Though in God's providence, I would say, I'm glad I'm here. I'm very glad to be here, despite being abused and injured by this loan shark. Fraud on the court is done by the lawyer and by flexibility to bring this on and to persist in it. If fraud on the court, this is a Rule 10 violation by the court. He had to rule on subject matter jurisdiction. Rule 2.7, the denial of my petition was illicit. He's okayed a criminal contract. He accepts the fraud of the court by the plaintiff, and he's denying the statute. So these are not just harms to me. This is a harm to our judicial process in Tennessee. This case should never have come here ever. And I reserve my time, 2 minutes. Thank you.
Thank you, sir. For the FLE.
Good afternoon, Your Honor. Our honors. Mary Cheadle on behalf of Flexibility Capital. The main issue today here is that this is an untimely filed an appeal. The motion for summary judgment that was filed in this case and pending for over 6 months was granted on December the 5th, 2022. That summary judgment was granted because there was never a dispute to a material fact. There was never compliance by the appellants as far as Rule 56.03. After the entry of the order of summary judgment, there was a motion to reconsider that was filed, which under Appellate Rule 4, that would extend the period of 30 days to file the appeal. That motion then was also denied because nothing was addressed as far as what had occurred on the order of summary judgment. What was brought up at that time was an issues by the appellants of we're now going to claim fraud, and we're also on the day of the hearing going to claim that the court lacked subject matter jurisdiction. The court denied that motion, and that motion, an order was entered on January the 18th, 2022, denying that motion. Under Tennessee Rules of Civil Procedure 59.01, there's only one bite at the apple. after the entry of a judgment for the court to either reconsider it or set it aside or alter it. Appellants chose to try again, the same mirroring motion. They just called it something else. They called it a motion to set aside. That court properly denied that motion, said we've already addressed these issues. We've already looked at this and we denied it. But you have to go back to when the court denied the first motion, which was January the 18th, 2022. That would put the deadline for filing this appeal as of February the 17th, 2022. The appeal was filed on March the 8th, 2023. I'm sorry, 2023. Yes, I'm getting my years wrong, sorry. The order denying the motion to reconsider was entered on January 18th, 2023. So that would put the deadline as February the 17th, 2023. And this motion was filed on March the 8th, 2023. So this court actually lacks subject matter jurisdiction and must deny the appeal as untimely. The trial court, to go back to those proceedings, properly filed a motion for summary judgment, which has not been addressed on this appeal by appellants. The motion for summary judgment, as I said, had been pending for 6 months. The court was gracious enough in this case to continue to allow the pro se defendants time and time again and recommended that they look at Rule 56. They did not. There was never once a dispute of a material fact, and the court properly granted the motion for summary judgment. In fact, throughout the pleadings of this case, the appellants admitted that they entered into the future receivables purchase agreement. They admitted that they received the money from my client, and they admitted that they failed to pay. There's no other issues. Now, appellants want to bring up a new issue of fraud that was not brought up until after the granting of the judgment. There's not been fraud in this case. It's not been shown. They also want to bring up, and of course, that's also a Rule 8 affirmative defense. The proper time to bring that up is not after judgment is entered. Second, they want to bring up that the circuit court in Hamilton County lacked subject matter jurisdiction. Circuit courts in Tennessee have the authority to hear a breach of a contract case, which is exactly what this was. Nothing further.
Thank you. Yes, sir, your rebuttal.
Is it 2 minutes that I have, sir?
Yes.
Yes, sir. In the brief filed by Flexibility, there's an effort to enwrap the subject matter jurisdiction claim in the affirmative defense argument and thereby kind of just make it go away. Well, I don't think that that's going to work. I don't think that when we're dealing with judicial infrastructure here on subject matter jurisdiction, that the failure of a defendant in court can be sealed, and his fate sealed by the fact that he failed in his ignorance to file a statement of material facts. The statement of material facts requirement certainly is a requirement in a lawful case, for a lawful contract, no doubt. But as we discovered in studying this matter and reading the law, there is no lawful claim for which a motion for facts can control. And we did see it late, but fraud operates on people and they can't see. They're being fog bombed by just not understanding what they're dealing with. And so when we realized what was happening, we filed the motion that was not repetitive and not redundant and not unauthorized. The motion was to set it aside, but also to allege fraud on the court, and that is not a redundant, prolonging the appeal time, let the clock run longer kind of case. It's not a motion to appeal a denial of a motion. I mean, we're not asking for the same thing. We're asking for something different. These are particular matters that I filed in this case, and I think it's erroneous to suggest that the case has to be thrown out because the defendant exercised all of his rights. The rules are not intended to cut off all possible appeal, righteous, proper appeal in circuit court. They're not intended for that. And by my reading of the rules and my discussion and my answer to her brief, I suggest that I filed my notice early before we even had the final dispositive judgment. There have been a bunch of judgments in this case, and my notice of appeal went in timely. Thank you, Your Honor.
Thank you. I want to thank you both for your presentation. Your case has now been submitted to this court for review.